Greetings. So the topic of the lecture, Introduction to Electronic Justice in the United States, focusing on legal regulation and technological aspects of the digitalization of the American judicial system. Legislation of different states, their impact on the uniformity of judicial practice, as well as technical solutions that contribute to the transition to electronic forms of proceedings are considered. The possibilities of introducing robots of judges in the American judicial system are analyzed. Possible consequences for the rights and freedoms of citizens, as well as for the development of democracy, are discussed. Okay, e-justice, also known as digital justice, refers to the integration of information and communication technologies into the judicial system to enhance efficiency, accessibility, and transparency. So, electronic justice in the United States is a relevant and significant topic for scientific research, since the digitalization of the judicial system can significantly increase the efficiency and accessibility of justice. E-justice or electronic justice involves the use of judicial technologies to streamline court processes, enhance access to legal services, and improve efficiency within the judicial system. In the United States, this encompasses electronic case filing, public access to court records, virtual hearings, case management systems, and emerging AI tools. Unlike centralized systems in some countries, US e-justice is fragmented due to the federal structure, with initiatives at the federal, state, and local levels. It's important. Managed by entities like the Administrative Office of the US Courts and state judiciaries, these efforts aim to modernize and overburden system amid rising caseloads and budget constraints. As of January 2026, ongoing reforms, including the Department of Justice's digital accessibility rule and state e-filing expansions, are accelerating adoption. Let's talk a little bit about historical development. So, the roots of e-justice in the US trace back to the 1990s with the introduction of the case management electronic case files system in federal courts, allowing electronic documents submission and management. By the early 2000s, the public access to court electronic records service provided online access to federal case files, marking a shift from paper-based processes. State courts followed suit, with pioneers like California and New York implementing e-filing in the 2000s. The COVID-19 pandemic in 2020 catalyzed rapid digitalization. All 50 states and the District of Columbia, DC, issued emergency orders to enable remote operations, expanding virtual hearings and e-filing. By 2021, 67 states allowed e-filing for self-represented litigants in at least some civil cases, up from 37 pre-pandemic. Federal efforts evolved with the case management electronic case files rollout completed in 2022, enabling single account access across courts. Recent strategic plans, such as the Judiciary's IT modernization and cybersecurity strategy 2022, emphasize cloud-based systems and AI to replace legacy infrastructure. Well, US e-justice operates across federal and state levels, with commercial providers supporting integrated platforms. Let's talk about federal systems. Case management electronic case files handles electronic filing with next-gen enhancements for judges, staff, and filers, including mobile tools and streamlined interface. The public access to court electronic records serves more than 4.5 million users for online case access, with restrictions for privacy. The Case Management Modernization Initiative, launched in 2022, develops a cloud-based platform for case management, public access, and analytics. Remote hearings use courtroom technologies with the AV equipment and cloud AI solutions for hybrid proceedings. What means AV equipment? It's electronic equipment that combines audio and visual components to improve communication and presentation. Now let's talk about state systems. As of January 2026, 36 states, territories and DC have statewide e-filing portals for general jurisdiction courts, allowing unified filing without visiting individual courts. It's important. Examples include New York State Court electronic filing system, expanding mandatory e-filing to all civil actions by January 2026. Next example, Indiana e-filing system launches in spring 2026, replacing the old portal for tailored user experiences. Maine's electronic courts expands to more courts in February 2026 for all case types. Maryland electronic courts went statewide in 2024, supporting e-filing for self-represented litigants. Electronic justice in the United States is an institutionalized system of administration and enforcement of justice using the digital infrastructure of courts, including first, electronic formation and management of court cases and filing of procedural documents. Secondly, public electronic access to case materials. Thirdly, regulatory embedding of electronically stored information in procedural regimes of proof and disclosure under the federal rules of civil procedure, as well as fourthly, special electronic regimes of individual jurisdictions and courts, for example, e-filing in the Supreme Court with preservation of paper copy as official. Well, such a system combines technological means, procedural norms, and organizational practices, forming a stable digital environment for the implementation of the judicial function. So, summarizing what we can say, e-justice in the United States is a complex system regulated at the federal and state levels. Major legislation related to the digitalization of justice includes systems such as case management, electronic case files, and public access to court electronic records. So these systems provide electronic registration and case management as well as open access to court records. Differences in approaches to electronic litigation between US states are due to the variety of legal traditions and the level of technological readiness. For example, some states emphasize the integration of electronic systems with existing legal processes, while other states strive to fully digitalize all stages of litigation. This diversity of approaches can affect the uniformity of judicial practice, posing certain challenges to enforcement. An important aspect is that e-justice enhances the accessibility and transparency of trials. Electronic justice solves the problem of accessibility of justice, provides additional publicity of proceedings, and significantly saves money for participants in the process.